Ranking Member Graham, and distinguished members of the committee. On behalf of Independent Women's Law Center, and as the mother of 4 children, including 3 daughters, I am here to warn you, the ERA is a Trojan horse. It promises equality, but hidden inside the empty rhetoric is a laundry list of policies that will harm women and girls. Back when the ERA was introduced in the House in 1971,
I asked the Capitol Police to enforce.
The more we delay the trial, the more poor women pay. Every day, poor women are told that they have no constitutional basis in court, and yet they seek justice just like we do. Women die every day. Women die every day because the ERA has been ignored. It is already ratified and ready. We can do it today. All Biden needs to do is pick up the phone and make a phone call to the constitutional archivist who will, in fact, ratify and publish the ERA. Poor women have no choice. They have been locked out of this process. I dissent. Using Ruth Bader Ginsburg justice as an excuse to delay this process is abhorrent.
Let's try to maintain order so we can get through this proceeding and have all points of view expressed.
So let's talk about Article 5 of the Constitution. Article 5 of the Constitution gives Congress an express power to propose constitutional amendments, including a power to propose their mode of ratification. And Congress usually does this via a joint resolution. Once that joint resolution passes by 2/3 supermajorities as required by Article 5, Congress's role under the Constitution is done. It's exercised all the power that it has under Article 5. And in fact, it is the entire joint resolution, including its preamble, that is then submitted to the states for ratification. The joint resolution that you would pass in your Article 5 capacity is the proposal itself. So preambles are therefore not only a part of the Article 5 proposal, they are often an important part because they often contain the mode of ratification. So let me give you a quick example. When Congress passed the Bill of Rights proposal, the preamble specified that those amendments, the first 10 amendments to the Constitution, those amendments' mode of ratification must be by state legislatures rather than state conventions. And the 23rd through 26th amendments, like the ERA, contain a 7-year ratification deadline in their preambles. So let's talk about the case law now. We've already mentioned Dillon versus Gloss. This is the most important Supreme Court case. The court there unanimously held that a 7-year ratification deadline that was contained in the 18th Amendment, the Prohibition Amendment, was judicially enforceable because it was an exercise of Congress's power to propose a mode of ratification under Article 5. Now, ERA proponents prefer to kind of ignore Dillon, and they focus instead on a plurality opinion that was penned by Justice Black in the 1939 decision in Coleman versus Miller. Now, Black's plurality in Coleman took the position, like the ERA proponents do now, that all ratification issues are non-justiciable political questions that Congress alone can resolve, not the courts. But of course, we all know, most of us in the room are lawyers, the Black plurality is just that. It's a plurality. It got 4 votes. The other 5 justices in Coleman, the majority of the court, took a narrower view and held that Congress alone can decide if an amendment has been ratified in a timely fashion, and, importantly, it can do so by specifying a ratification deadline in its proposal. If there's no ratification period specified by Congress in its proposal, like with the Child Labor Amendment, which was what was at issue in Coleman, then the court won't sort of superimpose one. The amendment will remain open indefinitely for ratification. And that's what happened, for example, with the 27th Amendment, which took 203 years to ratify and was ultimately ratified in 1992 after being one of James Madison's original 12 articles proposed.
So women get 7 years and congressional pay raises get
Please
203. This is
restore order.
for Biden to hide behind
Disruption is
the
not
fact that the
helpful.
ERA is ratified, it's ready, and must be published right now. This is illegal. This is a fraud. Women have equal rights right now. 38 states ratified the amendment. It must be published. This is, you're right, Congress's role is over. Publish ERA, Biden. Biden's a fraud.
I'm sorry, Professor Foley. Please proceed.
Yeah, no worries.